Good afternoon. Our next case is in re A.D.H, and we will hear from the appellant.
Thank you. Mr. Chief Justice, Associate Justices, may it please the Court, I am Kirby Smith with the Carolina Law Group in New Bern, North Carolina, and I represent the petitioner in this matter, the Carteret County Department of Social Services. Sitting with me today is Mr. Matthew Wunsch, who is the attorney for the guardian ad litem in this case. Mr. Wunsch will be arguing for the 10 minutes of my principal argument. At this time, I would like to reserve 5 minutes for rebuttal, please. This case gives this court the opportunity to examine the role of privity in collateral estoppel. Now, the facts of this case are fairly complex, but it can be boiled down simply to this. This appeal involves 3 cases: a custody case, an interference petition, and a juvenile petition that were heard and disposed in that order by the same judge. Each case involved a juvenile who we call Alice. That's a pseudonym. On August 29th of 2022, the department filed a petition alleging Alice was abused and neglected. A secure custody order was issued. 3 days later, the secure custody order came on for review by the court. The respondent father moved to dismiss the charges, and the trial court granted the motion, saying the issues were precluded under the doctrine of collateral estoppel because the judge had already determined in the custody case and in the interference petition that Alice had not been abused or neglected. The department appealed to the Court of Appeals and argued that the department was not a party nor privy with a party in the custody case and therefore could not be collaterally estopped, and argued that the court's order dismissing the interference petition was not a final judgment on the merits. The Court of Appeals disagreed, saying collateral estoppel precluded the department from raising issues previously determined in the respondent parent's custody case, and that the trial court's dismissal of the interference petition was a final judgment on the merits. We petitioned this court and asked this court to review the decision of the Court of Appeals. Now, collateral estoppel traditionally has 3 elements. First, you must have a final judgment in a previous suit. Second, the issue in the present case must be identical to an issue actually litigated and necessary to the judgment in the earlier case. And finally, that both the defendant and the plaintiff, or all parties, were parties to the earlier case or were in privy with parties to the earlier case.
Counsel, I'm sorry if I'm rushing you along, but what's the legal significance of Carteret County DSS referring the initial allegation to Craven County DSS because it had a conflict of interest?
I'm sorry, there was a conflict of interest, and so the department referred it to another department to be investigated.
Right, so isn't that like Carteret County saying, Craven County, you go act in my behalf because I can't do it here?
They did, yes ma'am. And in fact, Craven County investigated these allegations 3 times. Never were the claims substantiated. When the 4th allegation was made, Carteret County asked Craven County to investigate it again. Craven County declined. Statute 7B403, I believe, no, I'm sorry, it's in the 300s, requires the department to investigate these matters within 24 hours. So the department felt it had no choice but to investigate these allegations.
That was my next question. So it wasn't clear to me from the briefing. So the conflict of interest didn't disappear. Carteret County just felt like it was in a bind.
That's correct. There is a statutory mandate. That would be NCGS section symbol 7B302. When a report alleges abuse, the director shall immediately, but no later than 24 hours after receipt of the report, initiate an assessment.
And so Carteret County then, I'm assuming you agree, knew about the trial court judge's order that any examination needed to be routed through him. Is that right?
Yes, ma'am.
Why Why didn't they?
Well, first let me ask, what do you mean by examination?
Well, so initially, right, Carteret wanted to order another medical examination and another psychological.
Yes, the reason is, first and foremost, that's not in the record. And so I'm going to go outside the record when I answer. But Carteret County was not a party to the respondent's domestic case. Now, it's interesting that when you look at the orders in the domestic case, it's ordering social workers and counselors not to contact not to have contact with Alice about these issues, but they're not parties to the case.
Right, but didn't you just tell me, like, you sent it, Carteret had sent it to Craven 3 times, they sent it again, but Craven wouldn't do it? I mean, certainly it doesn't seem plausible to me that Carteret County was unaware of the trial court judge's order. And so I say this all to say is I'm really struggling with why this is a good case to get into, particularly the privity issue of collateral estoppel, because it seems like it's a situation where Craven County was in an odd spot and asked Craven County to do something and possibly had a special relationship in light of that, that this may not have the broad impact that certainly the amici would suggest.
There is privity between the Carteret County DSS and Craven County DSS. We don't argue that. The problem is the privity between the department and the parents in their domestic case. Because the parent, the judge in the domestic case is saying, I did not find abuse or neglect here in this case. And what's happened is when you have the interference petition, it's dismissed the same day, even though it contains a new allegation that came on March 28th. And the judge is saying, I've already said, I don't believe that she was abused or neglected. And so what we're having here is a blurred lines between a custody case in domestic court and an abuse and neglect case in juvenile court. And so I do think it's a good case to look at privity, because while we're in privity with Craven County DSS, we being the department, we are not in privy with the parents in their domestic case. And what you see with privity is this court in Masters v. Duncan, it's a 1962 case, said there's no definition of the word privity that can be applied to all cases. But then in State v. Beasley, this court said absolute identity of interest is essential to privity. And I think that's an important issue. I'm going to jump ahead a little bit. You have to look at what the issues are in each case. In the custody case, it is initiated by parents filing a complaint in domestic court. The issue there is which parent of the two is best suited to have custody of the child based upon the best interest of the standard, best interest of the child standard, and as proven by a preponderance of the evidence. In a juvenile case alleging abuse and neglect, here it's brought by a petition by one of our counties, one of our states' departments of social services. There, it is filed in juvenile court. It makes allegations of abuse and neglect. There, the department must prove the allegations by clear and convincing evidence, which is a higher standard. And there, the issue is, was the child abused or neglected, in this case, Alice? And if so, how do we make her safe? Custody is not the issue. So if you're going to look at collateral estoppel, we don't have identical issues here.
So I guess what I would focus you in on, because I think it's more relevant, is the interference order and the fact that it was related to some of the same methods and procedures from issues that came up in the custody order, which is to say in the order on the interference petition, the trial court judge is saying there's bias in how these investigations are happening. And you're saying Carteret is in privity with Craven. Craven is the one pushing that interference petition. And the trial court judge is also reiterating this is the same person to whom the unsubstantiated complaints were made. and there's coaching. So, I mean, I understand and take your point about the difference between the custody order, but the interference petition seems to me to be different.
Well, I think the interference petition, um, I think it's problematic for one reason. It's not a final judgment on the merits. I mean, interference petitions are allowed under 7B 303, which basically is a tool for investigating these matters. If you look at the statute, it says it allows the department to file a petition when a parent is obstructing or interfering with an investigation by the department into allegations of abuse or neglect.
Yeah, that seemed to me to be the argument that I seemed the strongest to you. I didn't, but I'm not sure that I saw it articulated in the way I was thinking about it. So tell me if I'm missing something here. But it seemed to me that all the interference petition, the only remedy you can get when you file the interference petition is an order from the trial court that says to one of the, here would be parents, but the party that's interfering, stop. You must cease whatever you're doing that's preventing the investigation. It's outside the court system at this point. But so, for example, there'd be no way to begin a DSS sort of intervention into a family law case through an interference petition. You could never have the end result of that be an adjudication and disposition on abuse, neglect, or dependency.
No, not
That's
an
just not how it works. And so how could, and if we're sort of acknowledging here that the two social services departments are in privity with each other, but they cannot be in privity with either parent because, of course, the parents and the government do not share the same interests in this sort of proceeding, then how do we get to a place where whatever was adjudicated in that case is somehow in privity with the later abuse and neglect and dependency proceeding by DSS, since that was not what they were doing in the first proceeding? That's what I'm trying to figure out.
I'm not sure I follow Justice Dietz, but
Well, that was too long of a question. So my point is, isn't the nature of the interference petition mean that there's some constraint on whatever could be the collateral estoppel there? Because they just weren't a party that could have a full and fair opportunity to make the sorts of arguments that they're making in the later A&D proceeding, because all they can argue is stop interfering, whoever was doing it.
the only relief you get with an interference petition is basically access to the child, okay? And you can ask for an ex parte order to actually take custody of the child so you can do your investigation. But the very nature of an interference petition is we haven't decided whether or not to substantiate these claims of abuse or neglect. We have not filed a petition. We have not made allegations.
So is there just a hole in the statutory structure then? Because that's the only relief you can get for a successful interference petition.
Exactly.
But if you have a situation like you have here, where the same trial court judge has been dealing with DSS oversight of these accusations, and there's some problems with how those accusations are being investigated, understand that the DSS has to, future allegations, new allegations have to be dealt with. But if there's a problem with how we're going about this, is the trial court judge stuck letting this child be subject again and again and again to medical examinations and psychological evaluations when he's already found all of this coaching?
Well, actually, if you look at the original custody order, he didn't find coaching. That came in later orders. In the original order, it's paragraph 19, he says, I did not find abuse or neglect. He actually found both parents to be fit and proper parents to have custody of Alice, okay? I disagree with your assertion, though, that the investigations are flawed. I think the investigations worked the way they should have worked. The allegations were unsubstantiated. Now, into the repetitiveness, which I think you're alluding to about these examinations, it's coming to a head. The allegations have been substantiated. A petition was filed. Specific allegations were made that Alice was abused and neglected. But we can't go forward on those allegations because the judges said already in another court where DSS wasn't present and wasn't privy to a party, He said, I found that the child was not abused or neglected. Now, the interference petition was dismissed the same day it was filed.
But hold on, but that's what I was getting at, but, because you said they were not a party. And I mean, DSS, as I understand it, there's no authority for the court to say, no, I'm not letting you intervene and do the interference petition. It's just something of a statutory right to file. Am I right about that?
I believe so, yes, sir.
So it seems to me that DSS was a party in the proceeding. So the problem is not that DSS wasn't there. This is what I was getting at with my question is, suppose in that proceeding, DSS said to the court, oh, by the way, on one of the parents' arguments that the other parent is, let's say, abusing a child, we have a whole bunch of evidence we'd like to present on that as well. It doesn't have anything to do with why we think one of the parents is interfering with our investigation. Wouldn't the court say, yeah, sorry, folks, that's not why you're here. You're only here for the allegations in your interference petition. You can't put on evidence of anything else. And then my point is, well, then you don't have a full and fair opportunity to litigate that question. So collateral estoppel can't apply. It's not a privity issue.
No, it's not a privity issue. It's a full, whether we've got a final judgment on the merits question. The court's dismissal of the interference petition was a final judgment on the interference petition, but not on the allegations contained within it. A great example, Justice Dietz, is, I might be a little mistaken with the dates, but not by much. March 17th, the court entered its permanent custody order. Alice made these new allegations on March 28th. And they were new allegations that occurred allegedly after the custody order was entered. And it's reported, it's investigated, and when it goes before the judge, he says no. He says no to the interference petition. So those allegations have never been heard in any court.
On the interference, sorry. On the interference petition, could the judge have taken judicial notice of the prior custody order?
I don't see why not.
And if he takes judicial notice of the findings in the prior custody order, why wouldn't they have some preclusive effect? Because
DSS was not a party to the custody case. It's a different venue. It's a different burden of proof.
The burden of proof, ultimately the burden of proof is higher.
Right.
So it seems that if you have preponderance of the evidence and clear and convincing that given the findings in the prior order, it'd be very difficult for DSS to meet that standard.
I agree, but DSS wasn't party to the custody case to be able to present its evidence. I think a good corollary to that is we know that in the Dowling case from the United States Supreme Court and in the KA case from the Court of Appeals, they have said you cannot have collateral estoppel between two different venues with different burdens of proof. A good corollary would be a criminal case. If you were to take a criminal charge involving the abuse and neglect of a minor, there is oftentimes, if not always, an accompanying DSS case. Now, if the DSS case gets heard first in juvenile court by clear and convincing evidence and it's not proven, no one goes to the criminal court and says, well, it couldn't be proven in DSS court, so therefore it can't be proven in criminal court under a higher standard. And the reason is because they're different venues, different burdens of proof, different parties. You've got the district attorney in the criminal case, and you've got the department in the juvenile case. And, I kind of lost my train of thought there for a second. Forgive me. But the bottom line is the department's these allegations have never been substantiated before. This is the first time allegations of abuse and neglect involving Alice have been in juvenile court, where the state has been a party. I say state because the Department of Social Services is an agency of the state. And when you look at the privy cases coming out of this court, McGinnis v. Hall, the Halls were husband and wife. Mr. Hall was sued for a breach of contract, and Mr. McGinnis didn't ask for interest, and the court didn't allow it. So Mr. McGinnis sued Mrs. Hall to try and get the interest. And this court said there's privity between husband and wife. And when you look at the Whitaker case, the BioSigma defendant was actually a successor corporation. This court actually remanded it back to the trial court to determine if there was privy between the BioSigma Corporation and the successor corporations with whom Mr. Whitaker had originally been dealing with. And that is really the crux of the case, is anytime you have allegations of privy or collateral estoppel, it is incumbent upon the trial court to make findings of fact and conclusions of law to support the finding that there is a mutual interest, identical issues that are being litigated, and therefore privy exists and the party should be bound by a prior judgment. If you'll excuse me now, I'm going to turn over the remainder of my time to Mr. Wunsch.
Counsel?
Mr. Chief Justice, and may it please the court, my name is Matt Wunsch. I'm appellate counsel for the North Carolina Guardian Ad Litem program, and I represent Alice before the court today. And it's significant that nobody could say that at either the civil custody proceeding or the interference petition proceeding, because our program is not appointed until a juvenile petition is filed. And so Alice has been left out of this process until now. Her voice has not been heard because the trial court dismissed the petition incorrectly based on the doctrine of collateral estoppel, when there was not privity of parties, both between DSS in the different cases and between Alice as a party to the juvenile Chapter 7B case, but not to the civil custody case. And I wanted to speak a little bit to Justice Deese and Justice Riggs to your questions, I think, about the interference petition and how the dynamics of that played out here. I wanted to point you to Ms. Dorman, the social worker who testified at the hearing, was asked about those prior unsubstantiated reports. And she testified, this is on page 100, that the reason they were unsubstantiated is they cited the lack of continued contact with the father. And in the third case, the social worker cited the inability to do the functions of their job to assess for risk and safety. So what we have here, in effect, is a parent who has consistently refused to cooperate with an investigation, has prevented the other DSS agencies from substantiating a complaint or a report. Then you have the DSS agency file an interference petition to try to get the ability to fully investigate that claim, and then that petition is dismissed. So Alice's at least 4, I would count 6 or 7, including times that she's talked to social workers or other investigators following up on reports to other people, have never been able to be adjudicated until now. Mr. Smith talked about that, and Justice Dietz, I think it's what your question was getting at. There has been a real frustration of this policy and this child welfare system that it's supposed to protect Alice.
I'm just not sure in this interference petition order, there were factual findings that I think don't comport with that. So still feel bound by those factual findings. I wasn't there. Can you point me to where in the interference order you're getting support for the reason all those other allegations investigated by Craven, by Ash, that they were unsubstantiated because of Dad's interference?
Well, again, the first thing I would point to was Ms. Dorman's testimony. That was her explanation. And
that's
Your
what
Honor,
the trial court found.
And what I would point out about these orders, both the civil custody order and then later the interference petition dismissal order, the image that comes to mind for me is a Russian nesting doll. You have the judge who has made up his mind at the civil custody order stage saying, I don't believe this happened. Okay, that's sort of the inner core. Then you have the next level where he's saying, because I already said this didn't happen, I don't believe it happened at the interference petition stage. And then another zoom out at the time he dismisses the petition, I've already said twice I don't believe this happened. So it's all based on one determination that he made in the civil custody case. It's not evaluating that new evidence that has come in. And I'd point the court again to a statement the judge made after he dismissed the petition. He says, I encourage anybody who has not yet to sit and listen to the transcripts of the prior hearing to make yourself familiar with the evidence that was presented at the earlier hearing. That's 123 of the transcript. I think that is the judge telling us, I already made up my mind. I'm not listening to anything new here.
So I guess I think I've done a bad job of articulating because I'm walking through the steps, but to the point you're making about the interference petition, it seems that there's multiple layers to this, but isn't the issue there that, as I said earlier, the only thing the court can do in the interference petition is determine whether or not one of the parents is interfering with this investigation that's not yet in court. And if the first step of collateral estoppel was the thing that you're trying to use as collateral estoppel necessary to the outcome of the proceeding, any facts about the abuse don't have anything to do with the court's determination of whether one of the parents is interfering with the investigation, right? So that to me, it seems to me the collateral estoppel has to stem from the adjudication in the family law proceeding, the custody proceeding itself, where you would have to make that determination as part of the analysis. Am I missing something there?
No, I agree, Justice Dietz. With your larger point, one small caveat I would put to that is part of the interference, or the defense against interference, part of that is I had an unlawful excuse. So it would be to discuss the merits of the A&D petition, potentially. But I would say in a very limited way, that's not intended. Again, I think in the briefing, I pointed the court to the way the statutes are put together. This is all not happening in one proceeding. As you have observed, this is a preliminary proceeding that has a very limited scope. It's not intended to be a final adjudication of the allegations in the petition. So I'm sorry, I'm agreeing with you and then trying to attach a caveat to it, but it's a very small one, and I don't think it's determinative here. And I see that I'm already eating into our rebuttal time. If the court has no further questions for me, I'd like to reserve the rest of our time for rebuttal.
Thank you, counsel.
Thank you.
We'll hear from the appellee.
May it please the court, Chief Justice, Associate Justices, my name is Sunday Stevenson. I practice with the law firm of Schultz Stevenson Law in Beaufort, North Carolina. I practice with my co-counsel, Mr. Bradley Schultz. On behalf of the appellee respondent father in this matter, we are asking that this court upholds and affirms the decision of the Court of Appeals that was issued on September 3rd of 2024. I had a long legal argument planned out. However, I have been taking copious notes as questions have been asked, and I wanted to actually go through some of the questions and see if there can be a discussion or clarification on some of those issues. The first issue that I note was the questions about the conflict with the Department of Social Services. The Carteret County Department of Social Services employs an individual named Mrs. Blaylock. Mrs. Blaylock is the maternal aunt of the respondent mother in this matter, Lisa Collins. Ms. Blaylock, during her time of employment with the Carteret Department of Social Services, while the Department of Social Services was getting reports about Alice, Ms. Blaylock took it upon herself to go to social media and host a series of fundraisers on behalf of the respondent mother and included Carteret County Department of Social Services individuals, social workers included, in those fundraisers. This is of the record. It is in our motion. It is on the record on appeal. It is in our motions that were filed with the court. And in fact, social worker Kelly Dorman, who is a social worker who did not testify at the intervention hearing, the petition for intervention hearing, she actually testified at the August 29th, 2022 hearing that was addressing the petition for abuse, neglect, and dependency. That's when she testified. And she testified, yes, I participated in those fundraisers as well. And she acknowledged the conflict.
Does that matter if suppose we say, we had embraced, I think a part of your argument say that social services departments, the Department of Social Services, anywhere, any county, is always in privity with another county's DSS. It is, after all, just the government. It's in a different place.
Yes, sir.
So does that mean we really don't have to worry about, I mean, then it seems the real question is, but can DSS be in privity with a parent?
Your Honor, I would respond in this manner with regards to the conflict question that you have. It does matter in this matter. As my friend argued to the court and applicably stated to the court, there have been 4 reports to Carteret County Department of Social Services of alleged abuse. Craven County investigated 3 of those 4 and unsubstantiated all 3 of those 4. And that is after things such as expert witnesses have been retained and given detailed reports. Mrs. Rockwell, Dr. Rockwell is record on appeal, and her report clearly says, hired by DSS, but clearly says it is not likely that there was abuse. I cannot substantiate abuse. The only time that the abuse has been substantiated by a Department of Social Services investigating is when Carteret County Department of Social Services decided to take it upon themselves without curing their conflict and decided to do their own investigation using social worker Kelly Dorman, who admittedly has helped the respondent mother in this matter fundraise and fundraise for funds to pay legal counsel to litigate opposite the respondent father in this matter to get custody. So I would argue that it does matter as to the conflict when it comes to the issue of the fourth investigation and the substantiation by Carteret DSS, because they substantiated when no other DSS county would the quote-unquote alleged abuse.
But wouldn't it, until the court has accepted it as credible and made it a fact finding, then it still can't have any preclusive effect, any collateral estoppel effect. Like just the fact that DSS said these, I don't think these are substantiated, that's not going to be collateral estoppel on some future DSS proceeding. It would require the court to say yes, and based on your determinations there, I'm making a finding that it was not. It can't be substantiated, right? And so my point is, here, what I'm struggling with is, it seems to me the strongest argument for collateral estoppel would be if there was privity between, you could have privity between a parent and DSS, and then you would say the findings in the custody action were quite clearly the court needed to make those findings to reach the outcome that was in that proceeding. If there's privity there, then I think collateral estoppel applies. I'm having a harder time with the interference petition where I don't think those facts necessarily were required in order for the court to reach the outcome, and that which is part of collateral estoppel, if that's making any sense. So what I'm trying to figure out is, what's your best argument for how DSS can be in privity with a parent when it's the government and a parent in a parental rights case? It seems like they could never be in privity.
Right. So what I will tell you, first of all, with the petition, the order dismissing the Craven County petition, I would claim, and our argument is that this is a final judgment on the merits that disposed completely of this petition and all issues in this petition. It is. The issue in the petition that was filed in the Craven County intervention matter was there abuse. The issue is the respondent father cooperating or not cooperating with our investigation? And that issue, at the end, when this was dismissed, was completely resolved. There is the case, and I refer to it as Strumbo, but it is the Strumbo in the matter of Joni Strumbo case, and it is an interference petition case. And it's interesting when you read this case, I find nowhere in this case that it says that it stands for the proposition that an interference petition is not a final order, a judgment on the merits. I find nothing in this case that holds that. And in fact, there's no discussion at all in this case about whether it's an interlocutory order or whether it is a final order that's being appealed from. They just
I
go
think
straight.
I've done a terrible job this entire argument at conveying what I'm trying to say, but suppose we agree with you that it absolutely is a final judgment on the merits of the statutory right to come to court and say, we think this parent's interfering, give us a judgment that says, tell them to stop interfering. So if you came back and filed a second interference petition, the court would say, you already tried this and lost, the collateral estoppel. But how is it that the findings about the abuse or the anything other than what's needed in order to say the parent's not interfering was necessary to the outcome of the interference petition, and therefore is collateral estoppel there? I understand that it certainly was necessary to the custody order.
And I apologize, I did get off topic. The answer to that question is this. The order dismissing the petition, the interference petition, it makes detailed findings of fact, it does, that there was no abuse that occurred. It was perpetuated by the respondent father. It makes those. It made those findings of fact, and it's Judge McFadden, the same judge. He made those findings of fact after this is what happened that day in court. Intercourt, it was not an in-chambers ex parte. It was on the record, and it was a hearing. And while witnesses were not called, evidence and arguments was presented to the court. Initially, the Craven County said, initially Craven County said, we need a child medical evaluation, very intrusive. We need these things. By the end of the arguments and the presentation to the court, by then Craven County was saying, we don't need this anymore. And then the presentation was made by counsel for respondent father that you've already found that there is no abuse in this child custody action. We are wanting to submit evidence to you to show, again, no abuse by the father, because it is evidence, number one, of why you don't need a child medical evaluation in this case. Further, we want you to take notice of your prior child custody order and recognize that that order says nobody is allowed to talk to this child about past allegations. And we want you to do that because we want you to note in this order, the interference order, that the father had to follow your order from the child custody action. He could not allow the Department of Social Services to access the child.
I guess what I'm not understanding is if that's correct, and I understand, I think your friend had acknowledged that there could be circumstances where the finding that I don't think the abuse occurred is why you dismiss or deny an interference petition. But isn't what's odd about this case that if that is what the court was doing, the court never gave DSS a full and fair opportunity to litigate that question? Because didn't the court decide it based on evidence that was presented by the other parties and not by DSS?
Judge, Your Honor, in looking at the order and looking at the face of the order, it states that it was heard as to the interference petition and the court took evidence, and then it lists out findings of fact, and it is detailed findings of fact that it took into evidence. It took and it was arguments of counsel, it was presenting the child custody order, it took detailed findings of fact. The court gave Craven County Department of Social Services every opportunity to put on any evidence they had to contradict the findings of fact in this order. Gave them every opportunity. Not only did they not put on evidence and did not contradict anything in here, then they backed up and said, okay, we agree now, we no longer need to go into the father's house and we no longer need to do a child medical evaluation anymore. They backed up. And when they backed up and said, we no longer need these things, then the court decided to dismiss. I would submit there is privity in the interference petition. It is a final order judgment on the merits, and it is the exact same parties. Respondent mother, respondent father, and Department of Social Services. To get to your question as far as privity with the child custody order, mother and father, understandably, the Department of Social Services is not a party in that instance. However, and I'm following up on the Whitaker case, where the Court of Appeals went ahead and made some noises as far as privity. And does Whitaker slide privity and remove that element of exact privity needing to be shown or some privity issue needing to be shown? And does it move that to where there is a full and fair opportunity to litigate the issues? And I would say that is exactly what happened in the child custody case in this instance. And we know that's what happened because in the child custody matter, in the order that is entered in this case, social workers Jennifer Lohman and Rondi Johnson from Craven County Department of Social Services testified at the child custody hearing. They were called by the respondent father, and they testified on his behalf. And they testified that it was their position there was no abuse and the mother had been coaching the child. The other witness for the Craven County Department of Social Services that was called was a Dr. Rockwell, and she was their expert. And she was called by the respondent father and made his expert. And she testified similarly. I would submit that that gave, number one, the DSS an opportunity, Department of Social Services, first of all, an opportunity to intervene, participate in the child custody hearing. It also put the Department of Social Services on notice. This is what we're litigating. They testified, they knew. And at any time, they could have filed a petition for abuse, neglect, and dependency, and what would have happened? They don't have to formally intervene. There's a system, the statute. And they would have been the show at that point. At that point, had they filed that petition for abuse, neglect, and dependency, the child custody hearing would have come to a screeching halt. Jurisdiction would have gone to the juvenile courts, and the judge could have decided, upon motion of a party or his own motion, was he going to consolidate the child custody action and the Department of Social Services' new petition. So I would contend that they were given a fair and full opportunity to litigate had they wanted to and had they thought to at that time. I've taken the position that they did not, because at the end of our child custody hearing, what had happened was that there was no evidence of abuse by their own witnesses, by their own social workers, by their own expert witness. There was nobody that was going to testify that there was abuse. They could not file a petition. They had no evidence. And they did not file a petition until 15 months later. And when they did, it was through a Department of Social Services that had an inherent conflict.
You don't dispute that the Court of Appeals basically said that there were new allegations of abuse that needed to be explored in the abuse, neglect, dependency proceeding, correct?
Yes, Your Honor, there's approximately a 6-month period.
I'm sorry?
Yes, Your Honor, there's approximately a 6-month period that there is. My understanding is that the ruling is that from the time the child custody action concluded and his order was entered, that it is from the time the child custody action concluded until the Department of Social Services filed their petition on August 29th of 2022.
Right, and the Court of Appeals set aside the judge's preemptive dismissal of abuse, neglect, dependency. So that will go back for some proceeding, correct?
Yes.
And if there is a need to further investigate, if there's physical signs of sexual abuse with the new allegations, Department of Social Services would not be precluded from having that investigated, correct?
No, sir, they would not be precluded under the statutes, no, sir. Unless there are further questions, I would yield and give the remainder of our time to my co-counsel, Mr. Schultz. Thank you.
Thank you, counsel.
Mr. Chief Justice, Associate Justices, may it please the Court, I'm Brad Schultz from Beaufort, North Carolina. I practice law with Ms. Stevenson, and as you've heard, we represent the respondent father. I tried to take some notes on your questions because I think, with all due respect, you have gone to the heart of some of the issues, and I appreciate that. One thing to be crystal clear about, and it was really not acknowledged, Carteret DSS has been involved in this case since March of 2021. They have referred to Craven on several occasions, but they have been involved with it via their referrals. After 3 times when Craven did not want to touch it again, and Onslow did not want to touch it, they swing into gear, as the social worker answered me during her testimony, or Ms. Stevenson, like a 100-mile-an-hour freight train. They also know about the restrictions Judge McFadden has tried to place related to this child, who has been medically examined 3 times. Then Carteret files its petition knowing Judge McFadden has said enough is enough with this. They don't describe and read the order in detail to Judge McFadden over the phone. They're at the magistrate's office. And they get another invasive procedure order. August 29th really gives you a very good flavor of what's going on in this case. It's the first day of school. They have been denied contact with DSS per Judge McFadden has ordered. They go to this child's first day of school. And actually, if you follow their timeline, they remove this child from the school before they get an order, before they tell the dad, before they call Miss Stevenson. And the big pink elephant in the room is they're in the magistrate's office. Judge McFadden is holding court in the courthouse. They try to go to Judge Cherry first. He knew about the case. As y'all know, if you've been down there, Carteret is not the biggest county. Word travels quickly. Judge Cherry said, no, you got to talk to Judge McFadden. They do it by telephone. He's in the courthouse.
You say the 29th, this is the day that DSS files the A&D petition.
I'm sorry, Your Honor.
You're talking, the date in August you're talking about, that's when DSS filed the A&D, the Abuse, Neglect, and Dependency
Yes, sir.
petition.
August
The actual
29th.
petition. So, and just so I have the dates right, so in April is when the court enters the order that says you cannot substantiate the allegations.
The custody order was, the trial completed in March. I believe the order was filed on 5 April.
Okay, and then the interference petition is in June.
Yes, sir.
So when the hearing takes place, that leads to the March-April order. So the order after the March hearing. At that point, is DSS a party in the proceeding?
Are they an official party? No, they're a privy, and they're in privity.
Okay, and when you say in privity, you mean with one of the parents?
Yes,
or
sir.
both?
And with the proceeding, because they have now acknowledged finally that Craven is in privity with Carteret DSS. Okay, Craven DSS people not only did all the investigation, but testified during a 4-day hearing.
Right, but I'm just saying because you can't be in privity with a party unless that party is one of the parties in the litigation.
Yes,
And
sir.
so as of March, April 2022, there are only two parties in the custody case were the two parents, right? So
Yes,
what I'm
sir.
saying is in the theory you're articulating right now, DSS must have been in privity with one of those two parents in order for the April order on the custody order to be subject to collateral estoppel. So what is the privity there between DSS and one of the parents? How does
My
that?
position is they had an opportunity for a full and complete hearing on the merits, and they participated in it. Craven DSS, which is Carteret DSS. And as your opinions seem to be indicating, the focus is now more on, and if I'm misstating it, I apologize, but the way I read it is the focus is more on a full, fair, and complete hearing and their participation. Craven participated during a 4-day hearing. The irony is,
But what I'm trying to figure out is they were participating, but at that point as a government agency, not as one of the litigants.
yes, sir.
And so they must have been, in order to be bound by some preclusive effect, they must have been in privity with one of the parties there at that hearing. And I just am having trouble because I just have trouble conceptualizing social services ever being in privity with parents because they just don't have the same. The government's interest is never going to be aligned with the parents. It has a completely different, it sort of has to step in loco parentis when it thinks the parents are not doing what parents need to do, and instead, in the interest of the state, it needs to step in.
I think they were in privity to the issue litigated, which was alleged abuse, sexual abuse. There was a full and complete hearing. and they're bound by it later.
So is your view of privity that the full and fair hearing means equals privity?
I'm not sure under your decisions whether it equals it yet. I think it's moving in that direction, and I think you need to clarify it after the Whitaker or Whiteacre decision. I think it needs to be clarified for the litigants. But I see the direction, in my opinion, the court has gone, where the emphasis is on, was there a full, complete, and thorough hearing, and did these individuals participate in some fashion?
Well, they were witnesses, right?
Sir?
They were witnesses.
They were not only witnesses, Your Honor, they were investigators.
Well, they testified
They sure did.
as to what, and they were called by a party
That's
to come and
correct.
testify.
Yes, sir.
But surely you can envision multiple times when someone may testify in a trial and then in a subsequent trial, whatever the finding may have been in the original trial where the person was just a witness, they're not going to be bound by the trial court's decision in that case.
I think I would, with this caveat, I think the issue of whether or not there had been abuse to these children prior to the testimony in the custody trial, and they participated, and that permanent custody order is not appealed.
Well, the DSS couldn't appeal it. They were just witnesses.
The mother could have appealed it, but it was not appealed. And I think those findings are binding going forward. It's a permanent order. Now,
But not to parties that didn't participate. It's a binding order as to the husband and the wife who were participants.
It is. And should the court give it a preclusive effect for DSS later because they participated in this proceeding thoroughly? And I think the answer has to be yes.
Did they call any witnesses?
Did who call any witnesses?
Did the government, the DHHS?
No, sir.
They weren't a party.
They were not a party.
They didn't have the opportunity to make arguments before the court?
As a party, they did not. No. I concede that. But when I look at the amicus briefs filed, and there's a concern that if you look at a preclusive effect, it could somehow cause people to gerrymander custody cases to stay away from a DSS investigation. I don't buy that for a minute. This was a 4-day custody trial. And as one of the justices has alluded to, the standard is preponderance. If you could not prove abuse by preponderance, how are you going to prove it by clear and convincing in juvenile court? It's not going to happen.
I mean, I understand what you're saying. I guess what I'm struggling with is this would be, for me, a completely different case if the court had a hearing on the June interference, after the interference petition is filed.
The court did have
And
a
then
hearing.
at that hearing made took all this evidence. At that point, you have all this option to participate, and then the court enters these orders, including the custody order. In other words, in some way to say that when these crucial decisions were made by the court, that DSS was a party and had the ability to call its own witnesses, to question witnesses, to make its legal arguments to the court, and so on. And it seems to me like the key decisions were made when DSS was not a party in the case. It was just a case between the parents, but is being penalized for not in some way intervening then and participating more. And that's what troubles me.
I think that's a slippery slope for this reason. And you're talking about the interference petition. There was a hearing. Arguments and evidence was submitted as attached to the petition, the custody order. The hearing took place. Now, a judge could simply deny the petition, or make facts. How much factual basis should the court give? Maybe in hindsight, 2020, maybe more. I don't think the court had to make significant findings. But Judge McFadden, having been involved in this matter for a period of time, alluded to and references and finds as a fact the prior custody order. I believe he pointed out what needed to be pointed out, substantiating his denial of the interference petition. And what Ms. Stevenson said earlier, which I think is significant, Craven at the hearing conceded, hey, you know what, we filed this, but you know what, we don't need an independent medical anymore. Hey, we've been to the person's house, we don't need to go there anymore. I mean, so the petition is denied. But I think Judge McFadden wanted to make part of the record his basis for doing it, including the fact that there had been prior independent medicals. And I'm going to go one step further for you. It's outside of your question. Carteret knows all that. They filed their petition on August 29th. They know Judge McFadden has denied, or Craven backed off and said, we don't need it. And you know what? They asked for it and they did it anyway. That is just it's not tied to the precise legal issues, but I will tell you, as a representative for Mr. Hawley and looking at his child, it is very troubling to me. I have never been involved in a case with 4 independent medical evaluations of a child. And that doesn't mean anything other than it's bothersome. I want to leave you with one final point, because I think this was what this case is all about. If you look at page 62 of Ms. Dorman's testimony, she candidly tells Ms. Stevenson, we want to relitigate the issues. We want a do-over. That's what this is all about. And she was candid, and she told the court. The final point I would also reference.
Counsel.
I'm done.
Thank you.
Thank you.
So much. Rebuttal.
Yes, sir. Thank you. There were a lot of facts brought out during the respondent's argument. I'm not going to address those facts. I wasn't there. All I have is to go by is the record. I will point out several things. If experts did testify, they testified in the child custody case. They didn't testify in any other proceeding. The department was not a party to the custody case. We didn't have a chance to present witnesses, question witnesses, make an argument. We couldn't have appealed that decision. We did not have that right. Most importantly, Alice. Alice was not there at the proceeding. This state provides children with the right to a guardian whenever they have to go to court. Alice was not represented in that custody case. She wasn't represented through a guardian. So Alice didn't have a chance to question these experts, testify, question witnesses, make an argument to the court, or appeal herself.
Can I ask you about this?
Sorry.
Ask you about allegations that occurred after the date of the interference petition order. And looking at the August 29th juvenile petition, there are paragraphs that recite that a report was made after that June 17th interference order, but I'm not finding where it specifically says that the acts occurred after that date.
That would be, if you'll excuse me, in her statement in the juvenile petition. I'm not going to be able to find it off the top of my head. I apologize. Alice says this happens some days. Some days. It's a very generic phrase.
Thank you.
Justice Dietz, you asked about the interference petition. I apologize for not being able to address your questions well. I will say there's one thing that bothers me about the interference petition, and that is the findings of fact. We have findings of fact on interference petition where the department comes in and says, we're being interfered with our investigation, and we have the court basically make findings of fact that the abuse and neglect never occurred. That wasn't why the court was there. That wasn't the issue before the court. This court, in McGinnis, Whitaker, and the United States Supreme Court have said it's a violation of due process to bind a party to a judgment when it was neither a party nor privy with a party in a prior case. That's protected under both the North Carolina Constitution, Article 1, Section 19, and the United States Constitution under amendments, I think it's 6 and 14. The department did not have an opportunity to be heard in the custody case. There's no doubt there. How can the department be in privy with a parent? Certainly not the father in this case. The mother, we don't know what her resources are. We know nothing about that. I would pray unto this court that it amend the decision of the Court of Appeals to send this back to the trial court for findings to determine what is privity, whether there's privity here and whether it applies to the department. And I would ask this court.
Thank you, counsel. Your time's
I
expired.
apologize.